name's Tyler Jones.
I'm Madeline Magnuson.
And we're here to give you just kind of a crash course in the U.S. legal system. To give you a rundown of what's going to happen tonight, we're going to spend the first 20 minutes talking about kind of the nuts and bolts of what does the U.S. legal system look like, how are courts organized, what the courts do, and how would a lawsuit progress.
And then we'll do about 20 minutes on types of law, so criminal, civil, torts, contracts, those kinds of ideas, kinds of disputes, and also how to read a legal case, which is something you'll probably have to do several times this quarter.
Lastly, we'll finish up with kind of a meta look at how the legal system reacts to changes in technology and society. And finally, we'll finish with any questions you have. But we also want to be clear, if you have any questions or are confused at any time during this presentation, shoot your hands up. We welcome that. The entire purpose of this presentation is to make it so that you understand the legal system. So if we've lost you, let us know.
Yeah, and there's a lot of legal terminology in the U.S. legal system, so we may accidentally use a word and not realize that it's not something that everyone knows.
All right. So with that, I'm going to get started on the U.S. legal system. So here is maybe a little bit of a confusing chart. This is a comprehensive look at what the U.S. legal system, or how the U.S. legal system is set up. And so there's a couple things that I want you to note, and we're going to go into more detail later. The first thing is I want you to note that there's two separate systems, that there's a state system on the right and a federal system on the left, and that those systems interact. Second, I want you to note that there's levels to the court system, that you have different layers of courts, and that cases are funneled up towards a highest court. So we're going to start at the very bottom, and that's trial courts, and you can see I've outlined in green what a trial court is. So usually when you're talking about a trial court, you're either talking about a state court of general jurisdiction, or you're talking about a federal district court. Now, a trial court's main job is to essentially establish the facts of what happened and apply to the law to those facts to determine what the legal outcome should be. Now, a trial court has some components that are mandatory and some components that will appear and disappear. So the most mandatory one is the judge. And so the judge will sit at the front of the courtroom. You'll then have the two parties. And the parties are usually referred to as either the plaintiff or the prosecutor. That's usually denoted by the Greek symbol pi. And the defendant, usually denoted in shorthand by the Greek symbol delta. So these are the three elements that are a necessary part of any trial court. Now, in addition to these three elements that will always be there when a court is functioning, you also may have a witness. And this is one of the major purposes of a trial court, which is to bring people in and to hear from them in court to determine the validity and the accuracy of their story. Now, in addition to that, another optional component in a trial court is the jury. So a jury is essentially a group of just regular citizens who are randomly selected and then screened to ensure that they're going to be able to apply the law and that they're going to be able to apply the law fairly. That is, they don't have any bias towards one side of the party or the other, or their bias is limited. But the thing is that these two components right here, they're optional. So a court can function without having a witness. It doesn't need to have the witness to call testimony. It can review just documentary evidence without a witness. The court can also function without a jury. So there's two types of trials, essentially. There's bench trials, which is where a judge decides alone. And there's jury trials, which is where the jury decides the issues of facts.
Sorry, how do we know which one? Like whether a trial is a jury trial or like a judge trial?
So for this, that's something that won't have a huge bearing on a lot of what you do when you're reading cases. It's just something that's important to note because sometimes when you're asking, when you go to the legal system, sometimes one of the parties will be able to demand a jury trial and be able to get 12 citizens who are going to be perhaps less sophisticated than a judge. And sometimes you're going to be able to insist on what's called a bench trial, which is just the judge. So there's some complicated procedure that determines which one is which, but luckily that's not something you have to worry about.
Thank you.
No problem. Any other questions? Okay. So that's the trial court. And that's, again, that bottom hierarchy, either in the state system or the federal system. Now, after you've had a trial at the trial court, if a party doesn't like the outcome, if they think that there was a mistake at the trial court level, they can file what's called an appeal. And essentially, that's a request for an appellate court to review the record generated at the trial court level for errors. Now, there's a couple important things to note about this. The first is that appellate courts don't hear new testimony. So at the trial court, you would have parties who are introducing evidence to try to convince the judge or the jury that their side is correct. At the appellate level, you can't introduce evidence. You instead are relying solely on the record that was generated at the trial court. That's going to be transcripts of all the testimony of witnesses. That's going to be copies of any documentary evidence that's been produced. It could even be physical exhibits. Exhibit is a fancy word for object that is considered legal evidence. So an exhibit could be a gun, it could be a document, it could be a strand of hair, it could really be anything. Now, here we can see that the appellate courts are a step up from the trial courts. So an appellate court has the ability to dictate to a trial court what it must do or must not do. So when an appellate court reviews a trial court's record, if it finds any errors, it will then either fix that error if it's a purely legal issue that it can do by itself, or if fixing that error will require the introduction of new evidence or was just so catastrophic that it prejudiced the entire trial and it just wasn't a fair trial, they'll what's called remand the case or send it back down to the lower court, that trial court, to redo the proceedings so that they're correct. Now, the final layer, the very top of this pyramid, is the Supreme Court. And so you'll note that it says discretionary review next to that. The Supreme Court essentially functions like a trial court. It's reviewing trial court decisions and appellate court decisions for error on the request of a party. But, and I'm going to say this just generally, you don't have a right to be heard by the Supreme Court. So, with the appellate court, you have the right to ask the appellate court to look at your case and to tell you if there's an error. With the Supreme Court, you don't, generally speaking, there's some exceptions to this, have that right. So the Supreme Court is only going to accept cases where they think that there's a novel or important issue of law that they need to decide. And the reason for that is something that I think Madeline's going to get into a little bit later, but essentially, much like an appellate court can tell a trial court what to do, the Supreme Court can tell any court below it what to do. And when the Supreme Court issues a decision, when they decide a case a certain way, future courts generally have to try to reach a similar decision in a similar case. That's the idea of precedent, or with fancy Latin terms, stare decisis. So as a result, because the Supreme Court is so powerful and can speak with such a broad, or paint with such a broad brush, they only take on the most important or large legal issues. Your run-of-the-mill dispute about whether something was true or not is not going to make it to the Supreme Court. Now oh, sorry, go ahead.
What is the logic behind the appellate courts not examining new evidence? It seems like you're trying to something down.
Yes. So there's a couple of reasons for this. One of them is logistical. And the appellate court usually has, essentially, it's not set up for the ability to take in evidence. So you're going to have in an appellate court some number of judges, usually 3, who will sit and decide a case. With a trial court, they're set up to handle that volume of documents coming in and people coming in. And additionally, an appellate court is actually, they're not looking for what you and I would likely consider error. They have this thing called standard of review, which means that they generally are trusting what the trial court did. And the reason for that is that what a conversation looks like in person is much different than what it looks like on a transcript, for instance. So the trial court has access to all sorts of information that the appellate court doesn't have. So really, all that the appellate court is doing for factual issues is reviewing the record to ensure that there wasn't a clear error by the trial court. There wasn't just something coming out of left field. But I agree with you, there are some inefficiencies in the system.
So when you said in the appellate court, so there's the judges and there's parties. The parties is just like the plaintiff and the defendant?
Yes.
Okay.
So that would be the trial court setup. Over here, you would have the appellate court setup with the J's being the justices. And here the terminology shifts a little bit. You would have appellant and appellee. No, respondent, and it varies depending on, but essentially the terminology will change to reflect that you're no longer in trial court where you have an individual suing someone else directly, but instead something has been decided and now one person is appealing and the other person is saying that that appeal is bogus.
And then at the Supreme Court level, it's petitioner or respondent because you're petitioning the court to hear your case because they can decide to say no.
Yeah.
You mentioned precedent in the Supreme Court cases. Do only the rulings of the Supreme Court hold that importance, or if some lower level of court rules in a certain manner, does that hold precedent with the other cases that will be considered?
That's a great question. So essentially, the idea in theory is that every court is binding on the courts underneath it. So the Supreme Court is binding on the appellate and the trial, and the appellate court is binding on the trial court. And there's also supposed to be what's called horizontal equity. So this idea that even though you're not bound, if you're an appellate court, for instance, and there's another appellate decision very similar to yours, you're not bound by it, but you should really strive to ensure that you're ruling in a similar way as that past court of an equal level has. Any other questions? Oh, yeah.
So when you mentioned that there are previous cases that were of similar context and there was some ruling that determined how to deal with previous cases, and other courts would have to follow those precedents, right, in their ruling, wouldn't there be a whole bunch of new things for judges to review all the time to be updated if that's the case?
Yes, I mean, that's absolutely right. I think that's why there's lawyers in the world, which is that for, there's entire industries that are dedicated just to allowing you to search and be updated on the cases that are being published. And also there's always arguments about whether or not the case that's before the court right now is really that similar to that precedent. There's always going to be one party who's saying, whoa, hold on a second. The facts from So all federal judges are appointed. State judges, it's going to depend on the laws of the state. And so that's the best answer I can give you just because there's so much variation between jurisdictions.
Is the appointment lifetime? You were limited?
Depends for federal judges. If you're what's called an Article 3 judge, that would be a district court judge, it's a lifetime appointment. Same thing for appellate and Supreme Court. If you're what's called an Article 1 judge, you have a fixed term, usually 5 to 10 years. For states, there's also variations. Some states have lifetime, some states have a set number of years. Many states have mixed systems. Some states even allow their Supreme Court justices to be elected, which is just crazy if you ask me. Okay. Anyone else?
All right, one more question. What's the difference between the state Supreme Court and the federal Supreme Court? Is it the matters you put upon the Supreme Court?
We're getting there. We're getting there.
Which cases have to be public? The records have to be public?
So that is a pretty complicated question. The general rule of thumb is that anything a court does should be public. There are, of course, exceptions to that. For instance, if you're dealing with particularly sensitive cases involving minors, then everything there would be private unless there's some compelling reason to make it public. If you're, for instance, dealing with, allegations of trade secret infringement, then those proceedings will generally be private because if you had a public proceeding, it would ruin the entire point of your lawsuit. So generally public with limited exceptions.
By what standards does the Supreme Court decide whether to take a case?
So that is the subject of much debate. It's not entirely clear. It's really completely up to their discretion. People will spend millions of dollars to hire lawyers who they think can craft the right thing that will catch the eye of a Supreme Court justice. Generally, what they're looking for is either something that's novel and confusing, and that having a precedent set early will be useful for courts, or they're looking for what's called a circuit split, and that's where two different appellate courts decide an issue differently. So now you have different rules of law, essentially, in the U.S., depending on where you live. That's not necessarily, there's many, many circuit splits that go on right now, but that's one of the biggest things that the Supreme Court will take up, just because it is a little absurd to say, the law is different, depending on where you live, because we interpret it differently.
So, what does that concept of magistrate, judge, and judge general? What's the difference between a judge and a magistrate judge?
So this is getting a little into the weeds here, but essentially there are some judges who are, and you might call them like mini judges. Like a magistrate judge is like a judge in that they sit in that courtroom, they hear evidence, they make decisions, they can throw you in jail, all of that, but their powers are really limited. They're only to apply to certain things. You can see all these examples, the administrative agency decisions, U.S. tax courts, U.S. claims court, all of these have judicial agents who have really limited scope, where they're a judge, but only in this limited, tiny area. And for a magistrate judge, for instance, they would actually sit below the district court. It's kind of like having a trial court even below your regular trial court. And the reason for that is essentially a district judge is a big hammer. They're someone who's appointed for life, they're really smart, they're really accomplished. You don't need to spend, that brilliant person's time on some minor issue. Instead, we can get someone who is, very smart and very accomplished, but who is able to just handle all of the really tiny minutia things and then pass up the bigger issues.
I have a question. So, decisions from the Court of Appeals are binding to the courts underneath.
Yes.
But I imagine that in the Court of Appeals there are lots of different judges. So if one judge issues a decision, or a panel of 3 judges issues a decision in a case, is this decision
So here's how it works, which is the decisions of a co-equal court are persuasive authority. So they're not binding, they're just considered very, very persuasive. How it also works is that there's a mechanism here that I don't have shown, which is there's kind of an appellate court within an appellate court at the federal level. It's called the en banc system. So essentially, if you have a panel of 3 judges who issue an opinion, before you appeal to the Supreme Court, or before that opinion is even final, all the judges in the Court of Appeals together can decide, well, we actually would like to hear this case as a collective. We're not going to limit ourselves to just what these 3 judges think. And so if enough of the judges agree that they should hear as a collective, then the judges, all the appellate judges in that jurisdiction, or a selection of like 10 or 12 of those judges, will get together and they'll issue what's called an en banc opinion.
And then all the appellate judges have to decide in the way the en banc decided in other cases.
Not quite. It's still just persuasive authority, but you have to think of the dynamics at issue here, which is if you have an en banc opinion saying something and you're a federal or you're an appellate judge, it means that most of your colleagues think this way, and the last time someone said they thought a different way, they all got together and said, no, that's wrong.
Okay, but then if you have a panel of 3 judges that issued an opinion in a way, in the same manner, but different case, and then a panel of 3 judges, appellate judges, that issue another decision in another way. The trial court, which of the decisions do they obey?
So they're really in a bind. So they would likely try to either pick the decision they thought was the correct approach, or they would pick the one where the facts were most analogous. But this is where the Supreme Court would come in. If you really had, within a single district, 3 different competing sets of case law that conflicted, either you would get an en banc opinion that would settle that, or the Supreme Court would step in and say, you're going to do it this way. Yes?
Do judges specialize? It's insane that one person has to decide literally everything. Like in the Appellate Court, do certain judges be like, yeah, I'm going to be on the panel of 3 for these kind of cases?
There is some specialization. It generally does not happen at the appellate level. Appellate judges are largely generalists. And the reason for that is that by the time that it works its way up to the appellate system, you're talking about questions of law, largely. So it's not really getting into and this is true only to a limited extent, you're not really getting into technical, factual disputes. Sometimes the law does turn on that, but largely you would, judges are generalists. There are some exceptions. Patent cases, for instance, there's a special circuit that just hears patent cases, and those judges are more specialized and technical, just because patents are necessarily more specialized and technical. So these are all great questions. We got to keep rolling. So now there's another huge thing about the U.S. legal system that's very odd, is that there's essentially a bifurcated system. So you have state courts, of which there are 50 plus all their subdivisions from there, the appellate courts and the trial courts, and there's a federal court. And these systems are not canon. They interact organically. And so how that works is that, it's a couple things. So first, in general, the federal law is supreme. In the U.S. Constitution, there's something called the Supremacy Clause. So if there's a direct conflict between state law and federal law, the federal law wins. Of course, there's lots of ambiguities with that. There's many times where federal law implicates state law or state law implicates federal law. And so as a result, even though we have a provision in the Constitution that gives us what should be a bright line answer, it becomes murky pretty quickly. Now, in addition to that, there's a couple areas where federal courts can get involved and can take a case that's been filed in state court and what's called remove it to federal court. And so you can see the 2 examples that are listed up there. And so these are set by Congress, and theoretically Congress could change these requirements. The cash requirement has certainly been changed many times in US history. So the two reasons you're in federal court generally are if one member of one state is suing another member of another state, that's called, and the amount in controversy is over $75,000, that's called diversity jurisdiction. The other one is if the case implicates a federal question or implicates federal law in such a way that the courts or the federal court believes that its expertise is necessary to ensure that there's uniformity across the land. So that's how you could get from a state court to a federal court. You can also have the reverse happen. So if either one of those two criteria is no longer true, for instance, let's say that you have a member of a state that joins in a lawsuit such that it's no longer completely diverse, as it's called, meaning that there's members of the same state on both sides of, on either side of the parties, then it's no longer eligible to be a federal court, and it gets kicked back down to state court to be decided there. Yeah.
What are federal questions?
So federal questions, and this is not something you need to know super well, but it's essentially if the issue in the case implicates federal law in a significant way. There's entire classes about what exactly constitutes federal question jurisdiction. So I can't give you like an easy answer, but just if you're looking at something and there's a federal statute that's at issue, that will likely be a reason for a federal court if it wants to step in and say, that's ours now. Okay. So that's kind of an overview of the structure of the court. Now we're very quickly going to go through essentially the life cycle of a lawsuit. So how a lawsuit starts off is one of the parties, the plaintiff, files a complaint. That's essentially a legal document that says someone has done something wrong to me and I want the court to make me whole again. After you file the complaint, the other party is then given a copy of that complaint and has a chance to respond. And so generally the response is, well, no, of course, this is not something there should be legal redress for. But the answer also could be, well, yeah, there's something bad happened to you, but I'm not responsible. Someone else is responsible, and you should sue them. And so that way, you could have defendants looping in a third party, either replacing themselves or having that third party share in the liability. Similarly, after you have a complaint served on you, you could say, if it's either in state or federal court, well, hold on a second, we're actually in the wrong court. We should be having this whole thing happen in another court. After you had the complaint and the answer to the complaint, you then would have what's called discovery. And so what discovery essentially is just a chance to look through or have the parties gather as many of the facts of the case as possible. And the reason for this is essentially to prevent trial by surprise. So I'm sure many of you have seen movies where there's a secret last-minute witness who comes storming in and it totally changes the case. Where the court system is set up explicitly to try to avoid that. They want that witness discovered early. They want those documents handed over early. And the reason for that is because there's a large amount of pressure to settle. So that's why settlement is up top there in bold. And what settlement means is that instead of having this go all the way through a trial where you're calling witnesses and there's a jury and they're deciding things and it's expensive and a huge waste of, not a huge waste, a huge expense of time and money, you would set up the parties agree that, something happened and we're going to walk away satisfied with these conditions. So that can either be what's called injunctive relief, meaning that you have a legally binding promise not to do something or to, do something. Or it can be monetary relief. Pay me X million number of dollars and this whole lawsuit will go away. And so you can essentially settle at any time up to the minute that the jury comes back with the verdict. Yeah?
So, I'm like, give me $10 million and I'll go away. And then a year later, I'm like, I discovered a new fact and I want to go back to court again. How does that work?
So generally you get one bite at the apple. So there's some very clear case law that says once you've agreed to settle a lawsuit, it doesn't matter if there were facts you didn't know. That's the end of it. And this is a precedent going all the way back to the common law where a man got hit in the head with a stick, and then he settled the lawsuit thinking, well, you know, it hurt a lot, but that's it. Literally days after he settled the lawsuit, a portion of his brain fell out. And he went back to the court and said, this is ridiculous. I would never have settled for this amount. My brain fell out. This is unfair. Let me get more.
How can you talk?
The court said, well, his lawyer did for it.
Okay.
And the court said no. They said this issue is settled. And that's something that courts have a very strong preference for. It's this doctrine, fancy Latin again, res judicata. As soon as something, a decision is set, as soon as the case is finished, it's done. And even though it might be a bad or suboptimal outcome, we'd rather have finality than have optimal outcomes in every instance.
So there's like a list of these are the exact charges we will never bring to you, and then the court sort of gets a copy and keeps it on file. It
depends. So settlements can either involve the court, where you have the court overseeing the settlement and being a part of the negotiations, or you can have out-of-court settlements. And I think you'll see this a lot of the time in news, for instance, where, you know, they settle out of court for an undisclosed sum. And so there, it's essentially a contract, which is, you know, just a legally binding agreement between two people to do something. And so there, you know, you could violate the settlement, you could violate the contract, and there the redress is, well, now we go back to our lawsuit, and we have an additional claim against you, which is, we had a deal and you broke it.
Are judges involved in out-of-court settlements?
Depends. That's the best answer I can give you.
So if it's that, my question was like go for federal question first questions. In addition to the question with the matter under discussion, is there any type of division based on the location of the state court or the federal court within the same level? So if there is a dispute, a litigation in New York, can I start that in any federal court throughout the United States? Or if it's a state question, can I start in any court, state court in New York? I need to find the right court within New York.
That's, again, a very simple question with a very, very complex answer. There's a lot of rules that govern where you can file a lawsuit. The general rule of thumb is that you can file a lawsuit within the jurisdiction where it happened. So if something went bad in New York, you can file in New York. The other rule of thumb is you can file where the defendant isn't home. So if you're a business and you're incorporated somewhere, someone can go and sue you where you're incorporated. The idea being that we're trying to essentially promote efficiency. So it's not efficient to allow someone to sue at any courthouse anywhere. We want to try to have the courthouse be as close to either the defendant or where the action happened. Yeah.
I have a couple questions. The first is on like timing. So are there like time limits that you need to adhere to for these specific steps, like discovery period, like X amount of time? I imagine it varies, but generally. And then two, can you give examples of like pre-trial motions?
Yes. So I'm going to be very quick. Your answer to the timelines. There are hundreds of pages of rules of criminal or civil procedure, hundreds of pages of state rules of civil procedure, spelling out all of that. So unfortunately, I don't know all of them. Now to just move through the rest of this very quickly, pretrial motions, that's essentially making motions either saying, you know, their case is bunk, we've done discovery, we can throw it out now, a certain piece of evidence is good, it should come in, a certain piece of evidence is bad, it should be excluded, they're experts in crackpot, you shouldn't let them testify before the jury. If you do let them testify, you should only let them testify about these things. So it's essentially just a formal means of the parties adjudicating the issues before them. So that is essentially the life cycle of a lawsuit in brief. You get the complaint, you have an answer, you have discovery, you then have any motions, you then have the trial, you then have a judgment, and then one of the parties could appeal. But the important thing to remember is over 90% of cases that are filed end up settled. That's true in criminal court, that's true in civil court. So really, when you're looking at cases, especially appellate cases, know you're looking at probably less than 1% of where most cases get.
And while you still have that slide up, I want to point out that for criminal cases, it's a little bit different. Very similar, but for criminal cases, called a plea bargain, where the prosecutor is agreeing with the defendant that he's going to plead guilty to some version of the charge, maybe for a lesser sentence. As well as the discovery is not nearly so big, because while the defendant gets to sort of compel discovery from the government side, the government doesn't get to compel discovery from the defendant. It's sort of like you can't be forced to testify against yourself type of deal. So what I'm going to talk about is generally the rules that all of these judges are applying all the time. And the basic idea is you have a lot of sources of law in the United States. So can anyone tell me the 3 branches of government that you all learned about in high school? Go for it. Go ahead.
Judicial, executive, and legislative.
Yes. So judicial, executive, legislative, and who knows which of those branches makes the law as their primary job. Exactly. And that's how we all think about it, and that is the source of a lot of law, but actually all 3 branches make law. So that is not a marker that works. Got the legislature, which when it makes a law, it's called a statute. And then you've got the executive. And in federal government terms, that's the president and all of the departments and agencies under his watch. And the classic high school version of what the president does is he enforces the law. But a lot of what the executive branch actually does is called administrative law. So you've got a lot of administrative agencies that Congress decides to delegate its lawmaking power to. So Congress passes the Clean Air Act and says, let's have cleaner air. You, executive agency, go figure out the details and use your technical expertise to decide on specific chemicals and specific amounts that people can't emit greater than that amount of a certain pollutant. Because our senators and representatives are not experts in that, and they want to give that to a technical agency that has the ability to make those kinds of determinations. So there's 2 primary ways that administrative agencies can regulate, and the first one is by passing rules. So for instance, if you've heard about Betsy DeVos, Department of Education, recently trying to pass new Title IX rules. So there is a whole branch of administrative law that is dedicated to that and the procedures that they have to follow. For instance, doing notice where you have to publish the new rule that you are proposing online and let everyone comment, and then respond to all of the meaningful comments. And if you get the process wrong, you might have to start over again. But there's another form of rulemaking or regulating that the executive branch can do, and that is through adjudication. And Tyler mentioned something called Article 3 versus Article 1 courts. Article 1 is the article in the Constitution that talks about the president and his powers. And the Article 1 courts are a whole bunch of courts that sit in the executive branch. And they are deciding things like immigration, who gets to stay as a refugee versus who gets deported. They are deciding, for instance, the National Labor Relations Board is looking at disputes between labor and management and deciding how that goes. And they can also be deciding on rules that they use, just as they could be deciding on rules of general application. And then you've got the judiciary. The high school explanation of what the judiciary does is that it interprets the law, and that is a ton of what it does. But it also can engage in something called common law. Back in the olden days of England, where our legal system sort of started, most law, arguably, was common law. So this is a judge, 2 people come to him with a dispute, and he's like, well, I think a decent rule is this. And then the next person comes along and he says, well, okay, that's kind of like this other case. I'm going to build on that last rule I came up with and extend it to cover this case. And over time, this iterative, centuries-long process, you end up with a whole ton of legal rules, which can all be preempted by statute. But if there's no statute on point, if there's no agency regulation on point, then the courts might get to decide it for themselves. But still having to pay attention to precedent and both binding and persuasive. And then overlaid on top of all that, you've got the Constitution and international law. Constitution is sort of setting out separations of powers and making sure, for instance, that agencies aren't going beyond the scope of lawmaking that Congress delegated to them, as well as federalism, so making sure that the federal government isn't overstepping its role where a state's powers should be reserved, as well as the Bill of Rights, which governs what states can do to individuals, mostly. This is the clicker, right? Okay. So that's sources of law in general, and here are a bunch of kinds of law. So you've got public law, which is facing what governments can do to individuals and sort of vice versa, and then private law, which is about what individuals can do to each other. So the public law side, you have criminal law, you have administrative law, which we've talked about, and you have constitutional law. And probably the most important three amendments for you to know for this class would be First Amendment, which guarantees people the right to free speech, freedom of assembly, and this comes up a lot when you're talking about, for instance, content moderation by algorithms on social media company platforms. You've got Fourth Amendment issues of search and seizure. So basically the Fourth Amendment says that the government can't do unreasonable searches and seizures of you and your property. And then, and a lot of, and then you've got the 14th Amendment, which has two really important clauses, which we'll talk about. The first is equal protection, which is that the government and states can't discriminate against you for a protected characteristic like race, gender, religion, etc. And then you've got the due process clause, which means the government can't take away your life, liberty, or property without due process of the law. Due process of the law, broadly speaking, can look like two different things. One is the legislature passed a law saying everyone has to give 10% of their income in taxes, and that counts as due process of law. But if the government comes to you and takes away your house, then they have taken away, without citing a law that said you didn't pay your taxes, then they have to give you a hearing and an opportunity to be heard to explain why they were wrong to do that. Yeah, go ahead.
So with 14th Amendment, is that under the law? So the law has to not discriminate, but does that enforce other types of non-discrimination, like hiring? Does that fall under this?
So it gets, there are whole law classes about this question. The 14th Amendment specifically says it's unconstitutional for the government, or so a state actor, to discriminate against you, but it doesn't necessarily bar private discrimination. So one person can still be racist to another person if they're both private people without that necessarily bringing the Constitution into it. But in the questions of, for instance, hiring or housing, Congress can pass laws that make it illegal to do that, even though it's not unconstitutional.
There are protected categories, and that's relevant to the class because of genetic information,
Mm-hmm.
for example. So I know genetic information became a protected class. Is that under the hiring? Is that under
I think that genetic material, I don't know the specifics, but it's definitely not a constitutional protected category. It's probably under a federal or state law, a protected category. And that is one thing to keep in mind with all of these sources of law I've talked about so far. You have to think about it times two. because there's the federal version and then there's the state version. And states have administrative agencies just like the federal government do. And there's state common law and federal common law, and it all gets very complicated and keeps us lawyers in business. Yes?
What would be the difference between a constitutional law and like a legal law? You just stated. How are they functioning differently?
Okay, so, right. So one source of law is constitution, other is statutes. That's kind of what you're talking about?
Yeah. So like, for example, the genetics thing, what would be the functional difference if it was a constitutional law versus what it is right now?
So law that comes from the Constitution, Congress can't get around. So if Congress passes a statute that says, you know, women should not be allowed to own property, then courts can say that law is unconstitutional, so it's invalid and it can't be enforced. But if Congress passed a law saying criminal convicted felons can't vote, then which a lot of states have, then that doesn't necessarily violate the Constitution, so it stays because criminal status isn't a protected characteristic under the Constitution. Does that make sense?
Yeah. So follow up. Is it very hard to change constitutional law?
Very, very hard. So to change statutory law, all you have to do is get Congress to agree that it's a good idea and pass it, which is hard enough, right? But to amend the federal Constitution, you have to do, there's two processes. They're both really hard and super rare. We have in total 25 amendments, roughly. And 10 of those were passed, you know, in the first 2 years of the United States being around. So they're super, super rare because you have to get, I think it's 2/3 of the states to 3/4 of the states to agree that it's a good idea. And that's one way, and the other way is to get both houses of Congress to agree by like a supermajority that it's a good idea. So that's the basic structure. Constitution is pretty fixed unless you're able to mobilize like this huge national coalition of everyone to think it's a good idea, which is why we still have the Electoral College.
When you say 3/4 of the states, how do you do that voting?
So that's either through state legislatures or if when Congress passes it to say like, all right, we're going to try to amend the Constitution, everybody, they can decide to call constitutional conventions in each state, so it's directed by the people if they want to try to get around the state legislatures somehow. Yeah?
Can the state legislator or federal legislator create rules that are completely against common law, or can the judiciary does not apply the law because it's against common law?
So common law is kind of the lowest on the totem pole of all of these. So Congress can always pass a statute saying, this common law is no more. We're going to replace it with a statute, and then the judiciary has to pay attention to the statute. We only have like 8 more minutes in the actual class. Tyler and I are both happy to stay after for more questions, but for now I'm going to try to move ahead to just a couple more slides, so you guys know a couple more types of things. And actually, I'm heading back to international law for a second. It's there, it's kind of wispy, it's hard to enforce it because there's no international police force, but it can come either through treaties, which is where nations get together and say, we all agree that none of us are going to use nuclear weapons against each other, or you can have something called customary international law, which is where enough states, enough nations over a long period of time all act as if something is an international law, it becomes an international law in a very bizarre process. So that rarely comes up in class, but for instance, it did come up with autonomous weapons. So kinds of disputes, we've been talking about criminal, administrative, constitutional. On the private law side, there's sort of 2 main ones that you guys might need to know about. There's torts and there's contracts. Contracts, you agree to rent your car out to someone, and then you give over the car, but then they don't pay you. Then you can sue them in court for breach of contract. And generally the amount of money you get back is called damages for however much money they had owed you, or maybe you had to rent out another car in the meantime because they wouldn't give you back your car so that you can get that amount of money back. But you generally don't get sort of like extra free money, and a lot of that money ends up going to lawyers. And then torts is kind of similar, but instead someone harms you in some way, like you're walking down the street and a car runs into you, you can sue the driver to pay for your medical injuries. And another type of, actually that just gets me to the next slide, which is another distinction in law between civil and criminal. Basic idea is civil is any time one private citizen is trying to sue another private citizen for something. Or basically when a private citizen is the one who kicks off the whole process by filing a complaint. They can sue another person, or they can sue the government if they feel like the government is, for instance, violating their 14th Amendment rights. Whereas criminal law, the only person who can kick it off is the state prosecutor, who's the one who files charges. And the other big distinction is in civil cases, the most you can get is money and maybe a court order that the defendant not repeat the behavior. But in criminal law, the defendant can end up in jail. And because because those are higher stakes, you end up needing to, as a prosecutor, prove your case that the person committed the crime beyond a reasonable doubt, which is a higher standard of evidence than in a criminal lawsuit, where you only need to choose that the person did the illegal thing at like 51%, which is called preponderance of the evidence. So all things being equal, are you more persuaded by the plaintiff's counsel or the defendant's lawyers? The mental state comes up a lot when we're talking about AI and either torts or crimes, because in the criminal context, in order to be guilty of a crime, you generally have to have had what we in law call a mens rea, a guilty mind. You have to have known that you were doing something bad. It's possible you didn't know it was specifically against the law, basically because that's too easy of an excuse to use, but you have to have intended to do the thing. So for instance, if I'm just dancing around on the dance floor and my hand goes like this and it hits, and like someone walked up and hit their nose into it, it injures their nose. I didn't mean to hit them. I was just going like this on a dance floor, which is very normal behavior. So I wouldn't be guilty of assault and I wouldn't be guilty of an intentional tort. But maybe I was being really careless by like going like this in a super crowded place and I hit someone. So it would be an accident, probably wouldn't be a crime, would likely be a tort. So that's kind of the balance of it with mental states. But where you have AI, it's really hard to say that the AI entity had a guilty mind because we're not sure that it's conscious or that it has intentions. So it gets really hard to, for instance, put an AI in jail or even potentially to sue an AI or an AI owner because the AI owner sent the AI on its way to do its thing, not intending for the autonomous vehicle to crash into someone, for instance. And then just so you know, because you probably are going to hear these terminology, 2 types of crimes: misdemeanors, which are the less serious offenses, and felony, which are more serious, is basically what that means. And then on the civil side, you have these torts and contract disputes, but you also have things like landlord and tenant disputes and divorce proceedings, which could come up in our class where, for instance, you have AI used as a decision maker or advising the decision maker in court. As well as product liability, which is essentially a special type of tort claim where you get to sue the manufacturer of some product for making a sort of negligently defective product. I saw a hand, yes.
So in a case where it's like murder or like assault or something like that, and the state takes over and does sort of a criminal lawsuit, what if does the defendant, so let's say there's some sort of fine associated with that, does that money go to the state, does it go to the defendant, or sorry, like
the victim.
Person?
Yep.
Can the victim actually file a civil suit in that case?
Yeah, so the imprisonment plus fines, there's actually a plus victim restitution there. And so fines would get paid directly to the state and sometimes into a victim restitution fund, which is where the state can use that to compensate people more quickly for damage done to them via crimes. So most of the money is going to go to the state, but there's also something called victim restitution, which comes at the very end after a person has been found guilty, which often takes years. But at that point, the person who hit another person can be held liable for the medical expenses of that person. And if the victim feels like they haven't been compensated enough, they can also go and civilly sue the defendant in civil court for more money. And for things like pain and suffering, which isn't going to be given to them in a criminal case. Yes?
Can a case move from the civil court to the like I'm thinking in product liability, that was like a drug or something like that.
Yeah, so it's totally possible for, in the course of a civil lawsuit, for some information to come to light that means a crime was committed, and for then a prosecutor to decide to file some charges. But in general, you still have the Fifth Amendment right against self-incrimination. So for instance, if you're up on the witness stand as someone who's being sued, if you decide to say, I plead the Fifth, that means that you did something illegal, or you're exercising your right to not incriminate yourself. So it's possible that ends up going there, but they can't actually force you to say what you did that's illegal, if that makes sense. Yeah. Those are kind of the most important things that I really wanted to get to, and we are officially at the end of class. So Tyler and I are happy to stay and continue answering questions, but I don't think there's any other material we really need to get through. Okay.